don't know if you can see me.
All right, everybody, welcome. My name is not Rod Escaola. I'm Graham McPherson. I'm his plucky and more handsome younger sidekick. I'm your condominium lawyer with Gowling WLG and host, at least for now, until Rod gets out of court. So he's currently held up. I expect we'll have him steering the ship again soon, but until then, you're stuck with me. Thank you very much, everybody, for returning to the Condo Adviser webinar. Tonight, the second webinar of 2023. We're going to be tackling the topic of tenants and tenancies. Tenants stand in a bit of a weird crossroads in condominium law. They're subject to the Condominium Act, they're subject to the Residential Tenancies Act, and that can result in some confusion about what their rights and obligations are. Now, this can be a bit of an issue because, as I'm sure we all know, tenants are very common. They appear to live in most condominiums, at least residential ones. So today, what we're hoping we can do is unpack some of the roles and obligations of the corporation, the owners, and the tenants, and how these roles and relationships crisscross with courts, the Landlord and Tenant Board, and the Condominium Authority Tribunal. And we're joined today by a fan favorite guest, Debbie McEwen, Manager Extraordinaire from CMG. Thank you very much for being with us, Debbie. And just as you were all getting used to me, Rod showed up in the nick of time to give his housekeeping speech, dressed in his finest robes. So with that, I hope you've enjoyed my hosting for the beginning. I'm sure everybody.
You lasted 4 minutes, and you're now fired.
Honestly, I'm drunk with power. I'm reluctant to give it up, but Rod is here in his best robe, so I'll hand the reins over to Rod. We didn't sink the ship.
Well, look at that. So good evening, everybody. And just for the record, it's not even my robe. I'm actually wearing Graham's gown today because there was a bit of an unforeseen hearing. And so look at that. I fit in his gown. And as soon as the show goes on, I'll turn my camera off and change. So welcome, everybody. I'm sure you... so Graham, did you do the housekeeping or not yet?
We did not. So it's housekeeping time.
How about you
I did the fun stuff. You do the boring stuff now.
How about you do it? I don't have my notes in front of me.
All right. Well, so some housekeeping notes, everybody. For one, as I said earlier, try to keep the chat alive. And I see some support in the chat for me. Thank you, everybody. Careful, you're going to grow my head bigger than it already is. But keep the chat alive. Feel free to post your comments, questions in there. Also, if you do have any questions and you don't want them to get lost in the shuffle, you can post them in the Q&A. We really do try our best to get to everything. Sometimes we can't get to it all, but we do appreciate you posting there. Also, for those watching our webinar, we do need to start with our usual disclaimer. First, please note that whenever we do refer to legislation, we're going to be referring to Ontario legislation. Those listening from elsewhere will just have to adapt to what we say to their jurisdiction. The information that we provide you is to the best of our ability, and it's accurate as of the date of this broadcast. So that's March 2023. Also, most importantly, please keep in mind that the information we're providing you tonight is general in nature and may not necessarily apply to whatever specific situation you're in. It's important for everybody to seek their own professional advice tailored to the facts and reality of their own situations. Finally, please note that we are required to inform you that this session is being recorded. It will be uploaded to the Condo Adviser website, and you can get access to it by visiting condoadviser.ca and clicking the webinar tab in the top right. We'll show that later. It can take a couple of days for us to get this up there, so don't worry, we will. Don't fret about that. It will be posted eventually. And with that, I think we can get into the meat and potatoes.
Hey, wonderful. And that
and
gave
Rod,
me...
you know what? I'm not going to give it back yet. Since I'm on a roll here, I'm going to go ahead and open the floor to you and Debbie, who are actually tackling our first topic, and that's the landlord's obligations.
Wonderful.
No.
And you know what we're going to do, folks? We're going to do two things. We're going to have a survey on how well Graham did. So maybe on a moving forward basis, he'll be the host. And something else we're going to do next episode is we're going to ask one of you at home to do the housekeeping. I mean, we've been doing this for 2 years. So one of you will get the chance to do the housekeepings. Okay, so Debbie, the first sort of segment of this presentation is going to be divided in three. We're going to talk about the landlord obligations. And then we're going to talk about the tenants obligations, and then we're going to talk about the condos obligation. Because as I said recently, I mean, there's a bit of a dysfunctional love triangle between all of these individuals or all these entities, and they're not playing on the same field, and that's the issue. So let's start with the landlord, Debbie. I don't know if Graham already mentioned that you wear a couple of hats today. You are a manager, but you are also very involved in residential tenancies. And so you have a lot of expertise in that field. And so let's start with the landlord's obligations in the context of a condo. What are they?
Well, landlord has an obligation to, firstly, when they decide they're going to become a landlord, they decide they've purchased a condominium or they've lived in a condominium for years, and they've decided they're going to change their focus, move out, rent it. They need to advise the condominium corporation that they have in fact moved, that they do in fact have a new address for service, so the records of the condominium corporation are up to date at all times. They need to ensure, not all condo owners know this, but the Residential Tenancy Act also has a list of prescribed forms that must be used in Ontario. One of those is a lease. The lease form is a prescribed form. It is a mandatory form to be used. And there is a box on that form that has to be checked if the rental property is in fact a condominium. And the landlord must certify in the lease form that they have provided the tenant with a copy of all rules and regulations and or governing documents that could impact the tenancy or the use of the home as a rental property. And that is signed by the landlord. So in essence, they're signing off that they have provided the tenants with those documents.
Okay, and so a couple of the capital sins here. Two problems I think that we encounter in the condo world, well, maybe three. One of them is that if the landlord, as you just indicated, Debbie, does not give the governing documents to their tenant, that's going to be their first excuse. Oh, I had no idea that I wasn't able to roast a pig on my balcony. Had you given me the rules, I wouldn't have done that. So the first problem we encounter as in the condo world is the tenants don't get the rules. So landlords give the rule. The second problem we encounter is that, as you just indicated, the landlord, if the landlord doesn't change their home address and continue to use their unit address as the address, when we send letters or demands or notices, it's going to the rented dwelling. It's not reaching the landlord. So you have to update your address. And the third one, and this is one that we see all the time, Section 83 of the Condo Act requires the landlord to advise the corporation within 10 days. It used to be 30, but it's within 10 days, the landlord has to advise the corporation that they've entered into a lease or that they terminated the lease or that they modified or renewed or whatever it is. Maybe a bonus question, Debbie. Does the landlord have to provide a copy of the lease, or can they provide information about it?
So a lot of condo boards and condominium managers get hung up on the Form 5. There is no requirement in the Act for a landlord to provide the manager or the corporation with the Form 5. The landlord has a choice. They can either provide the Form 5 or they can provide the signed lease agreement. As a rental company owner, I always prefer to send the lease agreement, which is a better document. It gives more information, start date, end dates, contact information for the tenant, and it's simpler for the landlord as well. It's not an additional form they have to complete. It's not an extra step they have to take. They attach the PDF and they send it off, and they are compliant when they have done so.
Okay, and maybe Graham, in the meantime, if you're able to find Form 5 on the web, maybe you can share your screen. So that's great. Moving on to the second block, we will talk about the tenant's rights and obligations. And Graham, double duty. While you're looking for the form on the net, you also have to tackle the next chapter. You're leading on that one. So what are the rights and obligations of our good fellow tenants? Are they second-class citizens, or what's going on here?
All right, so tenants do have rights and obligations, both vis-a-vis their landlord, the owner, and the condominium corporation. I'll start with the easier one first from the purposes of our conversation. Tenants' obligations to their landlord will come from whatever their lease is with the landlord and the Residential Tenancies Act. Obvious examples are things like making sure they pay rent and not damaging the unit, or if there's any particular rules in the lease, following those. But
Right.
that's not something the condo is going to be too concerned about.
Right, so I'll stop you there. So this is what you've covered now is how to be a good tenant. And I think
Yes.
now you're about to go how to be a good occupant.
Exactly. That's a good way of putting it, because the tenant's obligations as a tenant are those I've talked about, but as an occupant of a condominium, they have to abide by the Condominium Act, the declaration, the bylaws, and the rules. They are held to the exact same standard as any owner who's residing in a condominium. And the corporation has actually a duty to ensure that all occupants comply with this obligation. I think it's worth noting too that the Landlord and Tenant Board has actually acknowledged this obligation as well. I've got a quote here from a Landlord and Tenant Board case from 2016 that just confirms that it should be noted that pursuant to the Act, a condo corp is entitled to make rules, including ones pertaining to pets, the example in that case. Further, the occupants of a condo building are expected to abide by a condo board rules and/or bylaws. An owner is expected to ensure that occupants of a unit abide by the rules and/or bylaws. So the Landlord and Tenant Board is also aware of this obligation, but tenants are not able to breach the rules and kind of do whatever they want and use the excuse, well, it's not in my lease.
Right, exactly. And I think as you alluded, the condo corp really doesn't care if someone's a good tenant, but we certainly do care a lot if the person is a good occupant.
Exactly.
Because, right, absolutely. Maybe one of the questions that I saw go in the chat, people are saying, yeah, well, they're all like gung-ho about the Section 83 obligations to provide information, but like, what can we do when an owner doesn't provide this information? So what kind of whip can we crack? I don't know if David or Graham wants to tackle that quickly.
I mean, I can jump in. It's the same whip you would crack if there's a rule about dogs being a certain size, if there's a rule about smoking, if there's a rule about Airbnb. They
Right.
are breaching a requirement of the Act, and so that would follow the standard compliance process, whereby you would likely start with maybe a friendly letter. And I think we'll get into enforcement a little later on.
Sure.
But you'd probably start with some communication, and if necessary, escalate to legal, and if necessary, escalate to court.
Right. Okay, do I move on to the next segment? Are you done with your slides?
Yes, I am. And I can also stop the share. I'll just quickly show Form 5. I did find it, so here you go. Can everybody
Form
see?
5. Oh, look at that. This is before, I'm about to say something mean. This is before the CAO got to ugly our forms. That's an old form.
Oh, that's the old one. Well, enjoy it in all its
No,
beauty.
it's good. Yeah.
That's the quick result of a Google search.
No, you got the right form, but that's before the CAO got their a university summer student to ugly our forms. Okay, anyways, moving on. I think I'm going to get a letter tomorrow from the good folks at CAO. I'm not sure. David, I'm going to turn to you for the third element of the segment because this is a triangle. What are the condos' rights and obligations? So we dealt with the landlord, we dealt with the tenants. Now the condo.
Yeah, Graham, are you going to put the slides back up?
Yep.
Yeah, so the same sort of thing with dealing with occupants generally is, managing, controlling, administering the common elements, ensuring compliance with the governing documents and the Act. The difficulty that comes with this is often in this triangle of a relationship, well, sometimes condos don't want to deal with tenants. It's not our problem. This is for the landlord to deal with. We're going to hear a lot today from Debbie and from the other panelists. Don't take that approach, because there's still the obligations that fall onto the condo as the occupier of the common elements, and all the obligations to ensure compliance under the Act that do fall onto the condo that it needs to do on behalf of all the owners.
Okay. Let me just see here. Right. And maybe Debbie, let's deal a bit with that. And you're gonna have to wear two hats here. You're gonna have to wear your hat as a manager, but also as a landlord or someone from the landlord world. The old saying that condos don't deal with tenants. I mean, that has very limited use, I think. And so how would you kind of tackle it? What would be a healthier way of tackling that relationship?
I guess, you know, I'm going to preface that by saying that that mindset makes me crazy. The fact that we can, and some condominium managers do, attempt to avoid doing their due diligence and their job because the unit is tenant occupied makes me crazy. It doesn't matter who lives in the unit. If that individual is not compliant in any way, shape, or form, you must communicate with that individual. You must let them know. The difference is you include the owner in those communications. So you can send the communication to the owner and CC the tenant, or send a copy to the tenant by mail, but both parties should be involved in communications, especially if there's an infraction or a rule violation. But if it's just a report of unit maintenance that's required, something that the occupants observed on the outside of the home, to say I'm not taking that report because you're not the owner is just not something that should be done. We have an obligation to maintain the common elements. We have an obligation to enforce the rules, and we have to work with the individuals that make those reports until the relationship with the tenant goes bad. If the relationship goes bad, if they're hostile, if they're belligerent, if they're refusing access, if they're preventing you from doing your job, then we flip the switch, and the onus then goes to the owner, and the owner must deal with their tenant to make sure that they are compliant, they do provide access, etc. But at all times, try working with the tenant first. It makes the job easier. It eliminates the middleman that's going to have to, you know, do a lot of legwork to ensure that you can get your job done, and it just makes logical sense.
Right. And as you said, that is until things don't go very well, right? Let me just see if I can share my screen, because at that point, let me see if can I do this? Can I just like take over Graham's screen? Where's my, yes.
One way to find out.
There's only one way to find out.
Rod, I noticed in the chat somebody's mentioning property manager. So I guess I'm speaking because I am a residential property manager as well as a condominium manager. Many landlords are not managers. They are just homeowners that have become a landlord. So it applies to them as well. Right.
Okay. And so what I find interesting is that while you're trying to, first, I think what you said, Debbie, you have to try to resolve the issue as you would with an occupant, but you got to keep in the loop the landlord. When the relationship with the tenant falls off its rails, then your relationship with the landlord changes slightly, because while you need them as an ally, they become the target for the condo corporation, because our tools are stronger vis-a-vis the owner. We can crack the whip at an owner, we can charge back the owner, we can deal with the owner. And so what becomes difficult at that point in time is that you have to try to keep a relationship with the owner, but at the same time, you got to keep their feet to the fire. They have an obligation to take steps to deal with this matter. So I think now the image of the relationship with the landlord in that case is kind of this one. I don't know, am I sharing my screen? So during the day, on paper, you're fighting with the landlord. You're telling them the owner, that your tenant is, is a problem, and we're going to do this, and we're going to take you to court, and we're going to charge you. But at the same time, you have to work with them in order to try to get to the resolution. You need to give them information. You need to give them evidence. The owner needs to give you information, needs to give you evidence. And so it's an odd relationship, as I said, because you're kind of fighting with the landlord, but at the same time, you kind of have to be friends with Ralph at the end of the day to be able to get the information. Does that make sense?
That makes perfect sense, yes. Typically, I mean, what you see most often with tenant, condominium, and landlord relationships, things that go south are typically rule infractions. The tenants having parties, there's noise issues, backyard's a mess, what have you. Oftentimes, the landlord, if the condominium manager is experiencing issues with a tenant, oftentimes the landlord is experiencing issues with the tenant as well. Those kinds of tenants usually don't limit they're problem creating to just the condominium manager. So oftentimes you have a frustrated landlord who's trying to work with the condominium manager for a resolution with the tenant, but that landlord is hemmed in by the limitations given to them by the Residential Tenancy Act, because they have to jump through hoops on that end as well. So the very best strategy is for you as a condominium manager to give that landlord all the tools they need so they can have a strong and successful residential tenancy board filing to have a penalty or an eviction or some sort of sanction levied against the tenant via the RTA, typically get them out of the unit.
Mm-hmm. Okay, perfect. Moving on to the next topic, I guess, at this point, is we're going to talk about the collection of arrears. And I'm going to turn to you, David. And in this case, a minute ago, we spoke about how we can use the landlord to help us bring the tenant into compliance, but we can also use the tenant to help us bring the landlord into compliance if the landlord doesn't pay their condo fees. How does that work, David?
Right. So under Section 87 of the Act, there's specifically a mechanism that's set out there that if an owner is leasing out their unit to someone else and is in arrears of the common expenses, so the unit's in arrears and it's the owner who's responsible for paying the common expenses, the corporation can send a formal notice to the tenant requiring the tenant to pay their rent to the corporation directly to help, at least to the extent of the common expenses. So if their rent is more than the common expenses are, which I would think typically it would be if you're a landlord, you want to make a little extra so you can cover your expenses, at least that delta needs to be sent over to the corporation. So the corporation would say, these are the common expenses payable. You must pay it to us on a monthly basis. Here's where you pay it to. And interestingly, under subsection 5 of that provision, this actually ranks again in priority to anyone else who might have a claim over those rental arrears. So that rent. So sometimes you might have judgment debts, or you might have other things that allow you to take funds away from a tenant's rent. But the corporation gets the ability to send that notice and get that money paid into them directly to help pay off the arrears for the owner.
Right. And the tenant that does, and maybe you said that, but the tenant that does pay the corporation towards the arrears is not in default of their own lease.
Right.
Right. It's as if they had paid their lease, their rent. Okay, a good question that came up from David C. Could we have a different set of rules for owners and tenants? For instance, could we say owners can have dogs, but tenants can't have dogs? And I mean, this is a minefield. This is a beautiful question. I love it. And we were chatting on the sideline with Graham, and he says, "Oh, I wonder if that would be oppressive." And the reason is, yes, it's oppressive. But Graham, you figured out that tenants can't bring an oppression claim. So there we go. It's a Wild West out there. To answer that question, David, I would say this. You can't really have two sets of rules unless the rule is specifically applicable to the concept of tenancy. So you could have a rule that would regulate a tenancy, but you could not have a rule that would be owners can be noisier than tenants and tenants can smoke, but landlords can't smoke. You have to have the same set of rules for both. I assume that the person that could advance the oppression claim in that case, if you had a rule for your second-class citizen tenants, I think the person that could bring that oppression claim would be the landlord, the owner, and say, well, how is it that my tenant can't use the barbecue, right? So you can't really have a set of rules that differs unless it's expressly and specifically about the tenancy, as I said, like putting a limited, a minimum lease period kind of thing. Okay, so we did this. I don't know. Do you want to say a word or two about short-term tenancies? I think it's a good segue into that, David.
That was a good segue.
Yeah, I didn't have too much on that, more than just to say that, as we all know, it can be prescribed and limited in a number of different ways, and there's a lot of debate going on about how to do that, and I don't have too much more to add on that. I don't want to take up all the time, but. Yeah.
Okay, and Al raised a good point. He says we keep flipping between landlord and owner, and it's kind of confusing. So we're going to say landlord owner from this point forward. We're going to have to try to say that because obviously you're right. Sometimes we refer to them with one way and it may be confusing. So let's try to stick to that. Debbie, speaking of having different rights applicable to landlord and tenants, I'm looking at the agenda. Today may be the first time that we're going to run out of things to talk about. This has never happened. That's because we don't have Jason on the line. Everybody, don't tell him I said that. Okay, so Debbie, speaking of different rights applicable to tenants, what about the AGM? Do we have different rules applicable to landlord owners versus tenants? Can tenants attend an AGM, for instance?
Yes, tenants can attend an AGM as long as the owner of the unit that they occupy or another owner of the complex gives them a proxy to do so.
Right.
They certainly, under the Act, would be welcome to attend the AGM. I also, Rod, want to add this. I had a condominium that I managed for a significant period of time that had a tenant as the president of the board for 10 years. Their bylaws allowed for it, and she was an asset to the corporation, to say the least. So not all tenants are bad.
Well, of course not, of course. But you know what? You bring a good point, and we don't have that in the agenda. But that's a good question. Can a tenant run for the board? Does one of the two twins want to tackle that?
The lawyerly answer of it depends.
Yes.
If so the standard answer is if the bylaws don't say anything about this, yes. There's actually surprisingly little requirements of who can run for the board if the bylaws don't say anything about it. You have to be over 18. You have to not be a criminal. You have to be sane. So it doesn't matter if you are a tenant or even an owner necessarily. You don't even have to, frankly, you don't even have to have anything to do with the corporation. But some corporations like to tailor their bylaws such that only people who own units can be board members, or only people who own and reside can be board members. So there's no one size fits all answer to this. When in doubt, always check your bylaws. It's usually in the corporation's first bylaw, their operating bylaw, but sometimes there's specific ones about board qualifications as well.
Right, and what I've often seen as well is where the bylaw provides that only one of the seats can be occupied by a non-owner, but all the other seats have to be occupied by owners. So, I mean, again, as Graham just said, check your bylaws. Usually the operating one. Maybe it's been modified later. Okay, so that was a good question, Debbie. Good point.
Well,
Grant,
I want to just say this, like, Rod, there's a lot of condominium corporations that are heavily rented, that have, smaller condos, lots and lots of tenants, lots of long-term tenants. And some of these corporations struggle with getting people to come on the board. So opening up a window there to allow one seat to be occupied by a tenant is not necessarily a bad idea.
Yeah.
Yeah.
No, I agree. And I know of a condo corp here close to where I live who they have a tenant on the board. And I mean, he's working like 6 directors. So, I mean, I'm always puzzled a bit when there's that love-hate relationship between the owners who occupied their units and the tenants, as if the tenants were always bad people that didn't care about the environment where they lived. And so I don't think it's always true. So I'm going to turn to you, Graham, then. Next question. We're in the category now, folks at home, we're in the category where we're analyzing the different rights that apply to owners, landlord versus tenants. And so what about accessing records, Graham? Can a tenant access records?
So I'll back up the bus a little bit. The process to access records is the same as the process to deal with complaints of nuisance, pets, parking, and storage. And for those who have been watching our webinar, you'll know that that is operated through the Condominium Authority Tribunal, or the CAT. And the CAT's rules set out that only owners, mortgagees, and condominium corporations can commence applications before them. So that means that actually the answer is no. Tenants do not have a right to demand records of a condo in the same way that an owner does. Along the same vein, tenants are not able to commence CAT applications. So that does put tenants in a bit of an awkward spot if they are suffering from an issue of nuisance, or they are feeling like a pet below them or above them is barking and causing them problems. It's on the landlord slash owner to bring that CAT application. I think it's worth noting, though, that tenants can sometimes be the cause of nuisance or parking issues or pet issues. So they can be added as respondents in CAT applications. Just because they can't start them doesn't mean they can't be brought into them. But please do note, if you do start a CAT application about nuisance or something and you add a tenant as a respondent to that case, you have to also add the owner slash landlord of the unit, if not as a respondent, then at least as an intervener.
Okay, so I think you've tackled the two topics here at the same time. So one of them, I think you tackled the CAT applications and whether a tenant can commence one, and I think the answer to that is no, right?
Yeah.
And if you, the condo corp, are going to commence a CAT application against a tenant, for sure you want to include the owner, and I think that's of course that's a very safe and sound strategy. There was a case not too long ago at the CAT. I think it involved a noise issue, and the unit above, it was a sad story. The unit above had all sorts of medical equipment to assist with a heavily handicapped kid that needed help to breathe and to this and to that, and so the unit below was felt that there was too much noise. And what was interesting about that case is that the unit below sued the condo corporation and nobody brought the tenant into the equation. And it was very difficult to determine whether or not there was noise to the level that it became a nuisance. Okay, and you also talked about access to records. Tenants are not allowed to access the records. Only owners and mortgagees are allowed. Yeah, and in fact, there's a case, I keep saying not too long ago, but that's because I'm old, but there's a recent case where the owner commenced his CAT application to access records, but then sold and moved out, and then disqualified himself from being able to access the records because they were no longer an owner at the corporation. So if you're going to stir the pot, you need to have your feet in it. Okay, moving on. Enforcement involving tenants. So this is what we said we would tackle that. So we need to enforce our rules, our bylaws, our declaration. But now in this case, we need to enforce it against or vis-a-vis. We need to bring a tenant into enforcement. And so Debbie, again, you're going to wear your two hats. I'm going to first ask you to put your manager's hat, your condo manager's hat on. And how would you, like, step-by-step kind of thing? And I know we touched upon it a bit earlier, but how do you tackle this? Let's maybe if we use an example, there's a tenant that's quite noisy. How do you tackle it from the manager's perspective?
Oh, I could give you the long answer, but I won't. So first of all, you need to determine if the noise is in fact, I've had recently an owner complaining about noises because the tenant or the owner above him has a different lifestyle. He works night shift, so he comes home and makes food. So living noises are very different from noises that are a nuisance. So we typically will ask the individual that's complaining about the noise to describe it, to record it, to keep some sort of log so we can establish if there's a pattern. We will send a first notice or a warning to the individual that the complaint's been made about, advising what the complaint is. If it continues and we deem that it is beyond normal living noises, a second letter will go out, and then the final letter will be lawyers.
So let me stop you there. So you're doing the 3 strikes, you're out. That's fantastic. Are you copying the landlord owner on all these letters?
Absolutely.
Yeah. Okay.
Absolutely.
And then let's say it doesn't really work. How do you get the landlord to side with you? I guess
so
when
typically,
go ahead.
Yeah. So typically the landlord, when they are advised in the second letter that the next letter will cause them to incur legal fees, they come on side quite quickly. Generally, they then want assistance often because they're having issues as well and they don't want to pay the legal fees. If we have to send that third letter from a lawyer and the legal fees go on the owner's account or they're charged, absolutely, they are taking steps on their end to make sure that they are mitigating their losses. You're going to want me to talk about what those steps are, aren't you?
Sure.
Okay, so and most people aren't aware of this. We see it from the condominium manager perspective. We're sending these, 3 structure out letters, but as the landlord owner on the other side, they have a process that they must adhere to in terms of compliance with the Residential Tenancy Act. And the first step in that process is to give their tenant what's called an N5. Again, it's another prescribed form. It allows the tenant 7 days to correct the issue that's been brought to their attention, whether it be noise, barking dogs, smells, what have you. If the noise or the issue goes away within 7 days, on the 8th day there's been no further complaints, no other issues, then the matter is considered resolved. However, if there's another noise complaint, the same issue, within 6 months of that first N5, and a second N5 is issued, and the landlord owner can immediately apply to the tribunal for a hearing date for an eviction. It could take a year for all of this process to play out. The tribunal is backlogged at least 10 months. You cannot evict without a hearing. You can attempt to get your tenant to sign an N11, which is an agreement to vacate the unit. You can offer them compensation if they sign the N11 and get an agreement to vacate the unit on the specific date. But all of that to say that it's not an easy process for the landlord owner in terms of the Residential Tenancy Act and what they have to do to secure an eviction or compliance. As a condominium manager, what I like to see is that the owner landlord is working to get the matter resolved, is taking the necessary steps, and I will give them any document that I need to help them along the way. So that's the process. It's a lengthy one.
Right. Graham, I wonder if you can put us on the screen the N11 form. I'd like to see if the summer student that worked at the CAO also had a stint at the LTB. See if they uglied their forms over there.
I think we can track that down. Give me a moment.
Okay, perfect. In the meantime, so Debbie, I think you also covered a bit the landlord's perspective, and very well, actually. So they have to follow their own process. And I think what's really important for landlords on the line is you want to play ball, because, and I think either David or Graham is going to speak about that later, but the CAT and the tribunals, the courts, don't look favorably on a landlord that says, well, that's not really my problem. This is a condo issue. Debbie, as the condo manager, is all excited. Let her handle that. Oh, and while you're at it, Graham, if you can look for Form N5, Jordan says that one is more exciting. I'm not sure why. We'll find out. What's the
All
Form
right.
N5, Debbie? Do you know?
There's several different reasons that you can use an N5. So you can use an N5 to put your tenant on notice if there's a noise, disturbances, rules that are being broken, damages to your unit. I think overcrowding is another box that you can check. All of them allow for 7 days to become compliant or correct the issue that they're being put on notice about. The first N5 gives a 20-day termination time period. So either correct the issue or move out of the unit within 20 days. Nobody moves out of the unit. They don't correct. You can apply to the board to secure a hearing date for an eviction. But the N5 is one of the most complicated forms that exists with the prescribed
Wait
form.
a second. Have you seen have you seen a proxy lately? Like, what are you talking about?
Oh no, the proxy is horrible. But RTA Form 5, horrible form. Very
Yeah,
confusing.
I understand. I also had the displeasure of working with this form.
Yeah. So Form 5 then is for nuisance and breaking things, and the
Here's
one that we're
11.
and 11 is for what? It's for
That's
noise.
for an agreement that you would have your tenant sign
right.
that, you know, it
Yeah.
leaving the lease
So,
early.
Yeah. Well,
agreement to
nobody.
vacate. So,
Yeah.
yeah,
Nobody
the
ever
condo's
signs that.
coming
Keep
after
dreaming.
you. Yeah,
Yeah.
exactly.
Yeah. Good luck with that.
Oh
Sometimes,
no, I negotiated
sometimes
one of those recently. It can be done.
if you show up with money, if you show up with a money order for a month's rent, sometimes they'll sign it.
Or if the
Uh,
tenant wants to leave the lease earlier than the term provides, and you then want to get the landlord some sort of payout instead of forcing them to stay, you could also be used on that angle.
Right.
Yeah, exactly.
Okay.
Again,
And
though,
so
these aren't really forms that the condominium is probably going to be dealing with directly, but these are more the types of
Yeah.
things condominium's going to expect an owner, if there's an issue with compliance going on. These are the types of things the condominium is going to expect an owner to start working on.
right, you raise a very, very valid point. We sort of ventured outside of our comfort zone here with these forms a bit, but you're absolutely right. At the end of the day, that's really for the landlord to deal with that. Before we run out of time, now we're back to our usual. We're going to
Yeah,
run
there
out
it
of
is.
time. Yeah. So I'd like to cover the jurisdictions of these three bodies that are in fact regulating this dysfunctional love triangle. So I'd like maybe to get a sense of what's the jurisdiction of the Residential Tenancies Act or the Landlord Tenant Board, and what's the jurisdiction of the CAT, and what's the jurisdiction of the Superior Court of Justice. So we'll start with you, Graham, the RTA.
So for the RTA, we've gone into it already, but it governs the relationship, the direct relationship between landlords and tenants. And so the condominium doesn't really have a place there. Landlords/unit owners can apply to the landlord tenant board to evict their tenant. That can be for a variety of reasons, like non-compliance with the lease, damage, non-payment of rent, dangerous conduct, etc. And landlords can apply also if tenants aren't obeying condominium rules, and that's causing the landlord problems vis-a-vis the corporation. As we've said, corporations don't apply to the landlord tenant board, but they can encourage/require owners and landlords to do so. And it's also useful for if the owner or landlord does apply to the board, the corporation can assist. It can provide documents to help beef up the application and make its chances of success as good as possible, but it's not actually going to be running that ship. As Debbie mentioned as well, the landlord and tenant board is very, very busy, very, very backlogged, and so wait times can be quite significant, even in urgent cases. As for what the role of the CAT is in all of this, the CAT does not actually have jurisdiction to order evictions. So even if we're dealing with a case of nuisance or a pet problem or something like that, that is in the CAT's jurisdiction purview, the Act tells us that the tribunal will not make orders requiring a person to vacate a property permanently. So what the CAT can do is make compliance orders that, you know, thou shalt follow this rule, but it can't order eviction.
Can the CAT make an order requiring a person to vacate a property temporarily?
I
thought I had the same question actually. So
I
that's
don't think so,
interesting.
but I don't like. I mean, the wording of the act is that, but I don't think they have injunctive powers in
I don't
any
think
way.
they can either. Mandate
you know what?
on the way to cool off.
This is why we have David on the team. He's gonna find a way. If there's a David, there's a way. Okay, fantastic. And what's interesting, and I'm not sure who's gonna tackle this. Is it later where we talk about the current legislation versus what? Yeah, that's a bit later in the agenda.
Okay, I'll get rid of that.
Yeah. Okay. So, what about the Superior Court of Justice? When do we go to the Superior Court of Justice, David?
Things like Section 117, dangerous circumstances or urgent matters. Anytime you go to Superior Court on a tenancy issue, the court immediately gets nervous and doesn't want to hear it. So you really need to frame your application or action in a very specific way, either as a 117, a 135 oppression, but we're going to talk about what the act provides for and will not provide for in the future, but it's you can't just go to court for every small thing and frame it as something that it isn't. If it's a residential tenancies issue, the court's going to punt you back and say, well, I can't deal with this.
Right. So if folks at home, if you're getting a bit confused about which court to go to, I'm going to say this. If you're the condo corporation, you never go to the residential tenancy, the landlord and tenant board, because you're not a landlord. So you never go. That's really not your sandbox. You can't deal with that. You are then left with going to the CAT or going to the Superior Court of Justice. The CAT right now involves nuisance, records, parkings, pets, lockers. If you fit in one of those categories, you go to the CAT. If you don't fit in one of those categories, you go to the Superior Court of Justice. And as David said, usually the Superior Court of Justice deals with liens, dangerous conduct, and so on and so forth, oppression. And I think eventually the plan is to wean off our good tribunals from the fun of a good condo litigation. I think the plan eventually is to have a CAT that will be a one-stop shop. We'll see. Okay, termination of leases. And I think, Graham, you just indicated that the CAT will not terminate a lease. Okay, so, and we know that the landlord and the landlord and tenant board does have the power to terminate a lease, but we as the condo, we can't go to that to that party. We're not invited. So David, help us understand maybe, because I know there's a change, an upcoming change under the Condo Act. Right now, there's a power to terminate a lease, but it's complicated.
Yeah, so I think I put it up on the slides, but
Yeah, I'll get it back up there.
right now it's kind of an implied right that exists and has been used under an oppression remedy. It doesn't really say specifically what you can or can't do, but because an oppression remedy is so broad and liberal and the court can do whatever is fair or just in the circumstances, it's been used in order to grant eviction orders. With the new act, there's the provision that will eventually maybe be turned on or not. There's a provision in there that specifically deals with removal of an owner and expressly does not allow the court to remove a tenant. And it says you must go through the landlord tenant board. So this has caused some consternation and concern because it's taking away a power of a court that was there, even if it's not expressly so, and saying if it's a landlord tenant thing, it's got to go through that tribunal. And the theory behind that is you can't have there's one stream or there's another stream. You can't pretend to be a tenant board one day and a court another day and vice versa. So when that gets turned on, there might be some questions about, well, what about in those urgent circumstances where you need an emergency eviction or you need a restraining order or you need some sort of temporary injunctive relief? And I think that's going to raise a lot of questions about how to go about dealing with that.
And that creates an odd situation. So right now, currently, as the Condo Act reads today, if an owner doesn't comply under Section 134, you can seek a compliance order. And one of the things you could seek against an owner is to get them punted, to get them evicted because they're not complying. They're ungovernable, and so we're going to get rid of them. And currently, under the Condo Act, it provides that the court may terminate a lease. The Superior Court of Justice, that is, may terminate a lease, but only if first you got an order from the court against that tenant and the tenant breaches it. So there's like a two-step process. You need to get an order that says you shall not roast pigs on your balcony. And if they do it, then you can say you've now breached the order. And so we're going to terminate the lease currently. But as David indicated a minute ago, there's some provisions of the act that are not enacted yet that basically say you can't terminate a lease. The court can't do that. And which is funny because the court has inherent power. When I was in law school, that power came, from God, I think. Now it comes, and then it came from the crown. And now I think it probably comes from the will of the people. I'm not too sure.
Equity.
But they have inherent power. And so judges don't like to be told you can't do that. Okay, anything else?
Rod, I just want to touch on something we spoke briefly about yesterday, you and
yes.
I. The likelihood of a condominium corporation recouping its costs should it decide to push a landlord that's already trying to get their tenant to comply, has made applications, is waiting on a hearing date from the tribunal, and the condominium corporation either decides to go to CAT or the Superior Court of Justice, the likelihood that the condominium corporation would recoup their legal fees in that case. You had an opinion on that, and I'd love for you to share it.
And I think, Graham and David, are you going to talk about a case, one where you have the perfect landlord that doesn't get hit too hard on costs, and the other one is a bad landlord? Is that, or am I dreaming that up?
Actually, that's how the cookie crumbled. So I'm happy to talk about. I'll be covering the case about the good landlord, so I'm happy to talk about that now.
Yeah, let's do it.
It was a case before the CAT quite recently in 2022. I think in the summer it was released, and I mean, there's nothing too unique about the facts of the case. I mean, it was a case of a tenant who was smoking and causing some nuisance. The case, for anyone interested, is called MTCC number 1177 versus Brunet. But the tenant's causing problems. And essentially, I think the main takeaway of this case is that the CAT has almost no trouble finding that there's enough evidence here that this is very clearly a compliance issue with this tenant. So what are we going to do about the costs that have been incurred? And ultimately, the owner was not stuck with any of the costs because the owner had been able to show that, you know, I spoke with my tenant about this. I sent them letters asking to comply. I sent these letters to the condo to show what I had been doing. I sent them an eviction notice. I asked for an expedited hearing. The owner did everything reasonably available to them to help deal with the situation. And the CAT was aware of that, cognizant of it, and as a result did not feel that it was justified to stick this owner with the bill. And I think that's the right outcome, because what else are you supposed to do?
Right. Well, let me ask you this though: who ended up with the bill, the condo corp or the tenant?
In this case, it was ordered that the tenant would be responsible for the costs. And I mean, you know, the difficulty with that obviously is that the tenant it may be gone, or if they're not, it may be like squeezing water from a stone. Right. But I do think there is something to the court or whatever adjudicative body recognizing the reasonable steps taken by the owner.
Right. And you can't lean against a tenant. You can only lean against the unit. So there's some practical challenges when the landlord gets off the hook at the same time, as you just said. I mean, what can the landlord do? You can't be sending the goons. You can only do so much. Or can you send the goons? So let's go to David now, speaking of goons.
I don't know if you can ever send the goons. That is not the legal advice that's being provided here, but you do have the obligation to take some reasonable steps. And I just put in the chat, there was just a CBC article. You might recognize some names in that article from your favorite condo lawyers. There was a recent CAT case dealing with sort of the opposite situation where the CAT actually ordered substantial costs of over $26,000 to be paid, some by the condo owner and some by the owner and the tenant. So in that circumstance, it was a noise complaints, nuisance, and a very highly disruptive environment. And basically, the tribunal decided that, I mean, the landlord / owner has obligations to assist, to be involved, to try and not just wipe their hands of, oh, this is a condo issue, let the condo deal with it. And here the owner also wasn't really that useful within the hearing itself, and the tribunal kind of dinged them for their like passiveness in the process as well. So that's kind of the opposite situation, and we see it was a substantial costs award for the CAT, and there is a bit of a momentum there to start charging some more fees in that regard.
Right. And there was a prior case a couple of years back, the Peaches case. It involved a big dog, and its name was Peaches. And there were tenants that had all sorts of arguments that the dog was an emotional support animal. That turned out not to be true, and so on and so forth. And in that case as well, the courts tried to sort of do the Solomon thing and just like kind of divided the cost between the tenant, between the landlord owner. And of course, at the end of the day, who's usually held stuck holding the bag is the condo corporation, because whatever's not paid, well, the corporation pays its lawyers, and then everybody enjoys the benefit. Oh, that's interesting. I think we have Joseph Salmon on the line. Is that like from Lash Condo Law? We should promote that guy. We got 3 minutes to go. I wonder if that's him. Same colors. I recognize the colors from Lash Condo. So if it's you, Joe, hi. Anything else to add to these two cases? We're kind of running out of time. No? Okay, Debbie, anything to add? Did we cover what you had in mind when you asked the question about who's going to pay the piper?
Yeah, absolutely you did. Thank you so much.
Look at that, free of charge. Okay, so that kind of covers, I think, everything we wanted to cover today. Now, there's a lot to cover when we're dealing with landlord, tenants, and enforcement. You're used to it now. It's just like a fast and furious rapid fire during these webinars, and hopefully it gives you enough information to at least know what you don't know, and then you can contact your favorite property manager or your favorite condo lawyer to try to help you navigate the troubled waters of this dysfunctional love triangle. I wanted to use an image as well on one of the slides, but I kind of just got dissuaded when I Googled love triangle. That nothing was appropriate, so I kind of skipped that. But you can do it
You're
yourself
too
at
pure
home.
for the internet.
Yeah. Okay, so let's do the usual going around one last time. We got 2 minutes left only. Debbie McEwen from the condo management group here in Ottawa, also a landlord, but a good one. Thank you so much for joining us again.
You're very welcome. I want to apologize for the phone symbol. I'm doing this webinar from Lunenburg, Nova Scotia, and Graham and I were struggling to get some, my voice wasn't coming through, so I'm on the phone and you get a picture of a phone on your screen. So I apologize, but thank you so much for having me. It was my pleasure, gentlemen.
Hey, thank you. And enjoy yourself next week. You're going skidooing for a week or something.
I'm going snowmobiling in the Cape Breton Highlands on Friday.
Look at that. Look at that. Good on you. Send pictures. And now the two
Oh,
twins.
I will. I'll send you some for sure.
You know what? We may actually post them on the Condo Adviser. That's going to get some traction. Debbie McEwen with a snowsuit on. So Graham McPherson, condo lawyer extraordinaire with Gowling WLG. Any parting words of wisdom?
Any parting words of wisdom? If your boss tells you at the last minute that you need to rapidly step in and host a webinar, quickly make yourself scarce.
You did a fantastic job. I saw in the comments, everybody loved you more than they like me. So I think I'm retiring. What about you, David Plotkin, also a condo lawyer extraordinaire with Gowling WLG, the enforcer by excellence here. So any words of wisdom on the topic?
This is a confusing topic. There's a lot of, it's complicated when you have 3 different places to go, depending on who you are and what is happening. So don't feel overwhelmed. We're all here to help you figure out which path to go through, depending on who you are and what you need to achieve and how long you have to do it.
Okay, perfect. Graham, I think you need to put the slides deck back on for the parting slides.
There you go.
Yes. Okay. So thank you very much, everybody. It's 6 o'clock on the nose. Thank you for taking the time to join us tonight and take part in this webinar. Next webinar apparently is on April 5th. We don't have a topic yet, but I'm working with a condominium management star to join us. Maybe he's on the line now, and I'm hoping to get him to come up with a good topic. You will need to register again, and to register, next slide, I think. Yes, you will need to click on webinars. Please don't hate me. We haven't posted last month's webinar. We have a new team that's working on that. So the one on security is not posted yet. We're going to work on this. We're going to post this one as well. You'll be able to access it by pressing the webinar tab at the top of your favorite condo blog. So thank you very much, everybody. Enjoy yourselves. Hopefully there's not too much snow in your neck of the woods, and we will see you next month. Cue the jingle, Graham.